National Labor Relations Commission.
Good day, everyone. Are you a little bit curious where the labor cases are adjudicated or on how they function, their limitations? We are here to share some of those information with you. I'm Julina del Ocampo, together with my group mates, Zyrelein, Faye, Espejo, and Stela Calaunan. We will discuss some important facts and information about the National Labor Relations Commission or NLRC. NLRC is a quasi-judicial agency attached to the Department of Labor and Employment for program and policy coordination. It is mandated to adjudicate labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution.
In coordination with the DOLE, the NLRC is presently implementing the labor and employment agenda of President Ferdinand Romualdez Marcos Jr., which includes streamlined procedures, removal of red tape, restoration of integrity and fairness, and a much strengthened arbitration and adjudication system.
The National Labor Relations Commission was initially created on November 1, 1974 under Presidential Decree number 442 or 442. The NLRC was created together with the Regional Arbitration Branches or RABS, RABS,
On November 1, 1974, Republic Act No. 442 was enacted and created the National Labor Relations Commission and Regional Arbitration Branches. On March 21, 1989, Republic Act No. 6715 was enacted. It reorganized the NLRC and the RABS. On August 26, 2006, Republic Act No. 9347 was enacted and created 3 additional divisions in the Commission proper and provided for the deployment of labor arbiters as reviewer at the RABS. January 12, 2016, Republic Act No. 10741 was enacted. It is an act strengthening the operations of the NLRC, amended for this purpose Articles 220 and 222 of Presidential Decree No. 442 as amended, otherwise known as the Labor Code of the Philippines.
The NLRC, through its regional arbitration branches, has jurisdiction over unfair labor practice cases, termination disputes, if accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relations, cases arising from any violations of Article 264 of the Labor Code as amended, including questions involving the legality of strikes and lockouts. Except claims for employees' compensation not included in the next succeeding paragraph, Social Security, Medicare, and maternity benefits, all other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, whether or not accompanied with a claim for reinstatement. Wage distortion disputes in unorganized establishments not voluntarily settled by the parties pursuant to Republic Act No. 6727. Enforcement of compromise agreement when there is non-compliance by any of the parties pursuant to Article 227 of the Labor Code as amended. Money claims arising out of employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages as provided by Section 10 of Republic Act No. 8042 as amended by Republic Act No. 10022, and other cases as may be provided by law.
The Commission proper, on the other hand, has jurisdiction over cases decided by the labor arbiter, cases decided by the regional director or hearing officer on small money claims, cases of national interest certified by the Secretary of Labor, and petitions for injunctions or temporary restraining order under Article 225E of the Labor Code as amended. The nature of proceedings in the NLRC is non-litigious in nature. As such, the proceedings before it are not bound by the technicalities of the law and procedure and the rules obtaining in courts of law. The quantum of evidence needed to establish a fact in cases filed before the NLRC is substantial evidence. Substantial evidence is such an amount of irrelevant evidence that a reasonable mind might accept as adequate to justify a conclusion.
In the case of Angtibay versus the Court of Industrial Relations, GR number L46496, February 27, 1940, the due process requirements in cases filed before the NLRC are as follows. A. The right to present one's case and submit supporting evidence must observe. B. The tribunal must consider the evidence presented. C. The decision must have some basis to support itself. D. There must be substantial evidence. E. The decision must be rendered on the evidence presented at the hearing or at least contained in the record and disclosed to the parties affected. F. In arriving at the decision, the tribunal must have acted on its own consideration of the law and the facts of the controversy and must not have simply accepted the views of a subordinate. And G. The decision must be rendered in such a manner that respondent would know the reason for it and the various issues involved.
An action commences in the NLRC by filing a complaint in the Regional Arbitration Branch. It shall be signed under oath by the complainant or petitioner with a declaration of non-forum shopping. The case will then be raffled and assigned to a labor arbiter. A motion to dismiss the complaint may be filed before the date set for the mandatory conciliation and mediation conference on the following grounds: lack of jurisdiction over the subject matter, improper venue, res judicata, prescription, and forum shopping. Reply may be filed by any party within 10 days from receipt of the position paper of the adverse party. The labor arbiter shall motu proprio determine whether there is a need for a hearing or a clarificatory conference. The labor arbiter shall render a decision within 30 calendar days without extension. After the submission of the case by the parties for decision, even in the absence of stenographic notes. An appeal to NLRC may be filed within 10 calendar days from receipt of the decision or order. The appeal shall be filed with the Regional Arbitration Branch of Origin. Take note that the NLRC decision is appealable. However, the remedy is a petition for certiorari under Rule 65 of the Rules of Court. Subsequently, the decision of the Court of Appeals may be appealed before the Supreme Court under Rule 45 of the Rules of Court within 15 days from notice of judgment or final order or resolution of the ground of pure questions of law.